CUHK Law, and the latest in the Greater China Legal History Seminar Series. My name's Stephen Gallagher, and it's my great pleasure to introduce our speaker today. Our speaker today is Dr. Christopher Munn. He is the author of Anglo-China, Chinese People and British Rule in Hong Kong, and A Special Standing in the World, the Faculty of Law at the University of Hong Kong. He's a co-editor with May Holdsworth of the Dictionary of Hong Kong Biography, and his newest publication, co-author also with May Holdsworth of Crime, Justice and Punishment in Colonial Hong Kong, Central Police Station, Central Magistracy and Victoria Jail. Born, raised and educated in England, he served as an administrative officer in the Hong Kong government and in various positions in the Hong Kong Monetary Authority. He has a PhD from the University of Toronto and is an Honorary Institute Fellow of the Hong Kong Institute for the Humanities and Social Sciences and an Honorary Associate Professor of the History Department and a Research Associate in the Faculty of Law at the University of Hong Kong. So it's my great pleasure to welcome Chris Munn today and to hand over to him now. Thank you, Chris.
Thank you, Steve, and thank you lots for inviting me to take part in this series. And thank you to Erin, Vivian and Mark for all the technical support. Let me start with a mention of the book. Sorry. Yes, this is the book, and I'll begin with a thank you to May Holdsworth, my co-author on this project. The book is about three institutions whose buildings make up what we now call Tai Kwun, the old Central Police Station, the Central Magistracy and Victoria Jail. In this talk, I'll deal with the middle part of the book, covering the magistracy. My main focus will be on the decades before 1941, when the magistracy on Arbuthnot Road was the main court in Hong Kong, and it was known variously as the Police Court, the Central Court, the Magistrates Court, and the Hong Kong Magistracy. This is the building we know today. It's a rather grim-looking place, squeezed in between the jail and the police station. This building was opened in 1915, and it was finally decommissioned as a magistracy in 1984. I want to get on to the next slide, thanks. And here's a photo from about 1970 showing its position in relation to the jail and the police station. The magistracy is the dark roofed building on the far left side. And here's an earlier picture from 1920, not long after it was built, in a view from the Wyndham Hotel down on Wyndham Street. The magistracy is up in the top left-hand corner. However, for much of the period that I'm covering in this seminar, the magistracy occupied an earlier building on the same site, built in 1847. It's the building pointed out here with the left-hand line. Hardly visible, but here's a more visible picture of it from much earlier, from the late 1850s. And it was actually from here, from the parapet just in front of the magistracy building, where many of the hangings in the 19th century took place. Reliable pictures of the inside of the court don't seem to exist. Certainly none have survived. Contemporary descriptions tell of an increasingly dilapidated, badly ventilated building, crowded with people, its tables laden with opium paraphernalia and stolen goods. There were a few cartoons in the satirical magazine China Punch. Here's a picture from 1872. It's the results of an extradition hearing. The magistrate is F.W. Mitchell. The defendant is Lower Pew, wanted for robbing a jade shop in Chinese territory. And the man with the beard is Daniel Caldwell, a former police officer, court interpreter, and registrar general until he was dismissed in 1861 for consorting with pirates. Here he is as a self-described Chinese agent, helping Chinese sort out their problems in return for a fee. Lowe was discharged, and he's pictured here returning to the court with Caldwell to thank the magistrate, probably for saving his life. Now, why study the magistrates' court? Well, it's the oldest court in Hong Kong. It was first opened in 1841, and it continued even while the British were in internment during the Japanese occupation. The Chief Justice would occasionally hold a magistrates' court. It's also then, as now, Hong Kong's busiest court. It was an important tool for enforcing government policy, and it was a site of cultural exchange, a place, as one magistrate described it, in which are daily unfolded the tragedies and dramas of humble everyday life in this overcrowded colony. This was Paul Korff, one of the Central Magistrates in 1972, answering accusations that the magistrates were out of touch. The importance of the magistracy was also noted by governors and officials. Governor Bonham said very early on about the importance of the magistracy as a face of government to the Chinese inhabitants. As well, and it would be a test of the obedience that they will be disposed to pay to the laws under which they are permitted to reside. Note that presumption of alienage that is a constant theme throughout this seminar and throughout the colonial period. And then more tentatively, later in the century, the magistrate Henry Woodhouse puts forward a similar idea. It is in these courts that British rule, with its advantages and its drawbacks, is brought home most closely to the Chinese mind. This is the outline of the seminar today. I'll be focusing mainly on what we might call the high colonial period, which is the period leading up to World War II. And particularly the period around the turn of the 20th century. But if there is time, I'll go very quickly through some of the developments after World War II. Let's first remind ourselves of the political economy of colonial Hong Kong. It was a free port, as is well known, and that meant in practical terms that any revenue to the government had to come from internal sources. They could not tax trade. It was a crown colony, which meant that it had a very authoritarian form of government, centering on the governor. Gradually, there was some co-option of leading merchants and professionals, first Westerners, and later on Chinese. And there was free immigration in and out of the colony. There were no immigration controls or no effective immigration controls until the 1950s. Most people came by sea, and the only checks on arrival were the searches for illicit opium. Population growth was rapid, and the colony had a plentiful supply of cheap labor, which, just as much as Chinese capital, was essential to the colony's prosperity. Practically every activity was labor intensive, all the way down from the loading and unloading of ships in the harbor to the carrying of people around the streets in sedan chairs and the disposal by buckets of human excrement. Some governors attributed the very rapid growth in population in Hong Kong to the quality of British rule, and in particular to its legal system. Certainly, there was protection of private property and intensive policing. Even Sun Yat-sen praised the colony for its orderly calm, contrasting it with the insecurity and misgovernment in his own country. The whole of this period was a period of great instability in China, marked by external wars, civil wars, and revolution, and a great deal of banditry and predation, some of which targeted Hong Kong. Population pressure led to large movements of people, including emigration to the Americas and to other British colonies. Within Hong Kong, the bulk of the population was Chinese, male, young, and working class. They lived in crowded, unhealthy conditions, many in so-called coolie houses, others sleeping on the streets, simply because land was at a premium and rents were so high. And in the competition for resources, there were frequent outbreaks of violence between individuals, gangs of workers, different native place groups, and secret societies. These problems were intensified by the temporary sojourning nature of much of the population. Some people, of course, made Hong Kong a permanent or semi-permanent home, and a small but growing class of merchants, shopkeepers, and professionals increasingly asserted themselves, and their interests were very much aligned with those of the smaller foreign colonial elite. But let's just have a quick look at the population growth. Here it is by decade and by census year. A lot of officials and others thought that these were underestimates of the population, but it's the best that we have. And remember, the population was very fluid. Now, the legal system. I'll go through this quickly. English law, as it existed in 1843, was in full force, except where inapplicable to local circumstances. Legislation within Hong Kong was subject to disallowance by the Secretary of State, and the Colonial Office did exercise some supervision, but it was patchy and it was often resisted. And from the earliest years, there was an acknowledgement in London that because of its position on the edge of China, Hong Kong was a special case to be governed differently from other colonies. It was, said one Secretary of State, a place per se to be dealt with on principles which might not be sanctioned elsewhere. There was nevertheless a general policy of alignment with English law reform, although Hong Kong lagged behind in many areas and was quite selective in some parts. There was also a unified court system which applied to all nationalities in the colony. This was somewhat different from the system of extraterritoriality which prevailed in the treaty ports, Shanghai and elsewhere. Even so, there was a large body of discriminatory legislation, and most of it was enforced in the magistracy. And the criminal justice system relied heavily on summary jurisdiction and on interpretation. Well, here's a long list of the courts that were established between Hong Kong in 1841 and 1941. We can immediately exclude those in red because although they were legislated, they were never used. Those marked in blue were used for various periods of time, but in the end they were replaced or superseded. Usually the jurisdiction went to either the magistracy or the Supreme Court. I just highlight the petty sessions, which was an attempt by Governor Bonham to involve the colonial merchants in justice as justices of the peace. It was a complete sham because they only attended where they had interests of their own to promote. And in any case, the magistrate had all of the powers of the petty sessions on his own. So it fizzled out and was quickly replaced. So it all really boils down to two main courts, the Magistrates' Court, the lower court, and the Supreme Court, the highest court in the colony, from which appeals could go to the Judicial Committee of the Privy Council, although they rarely did in criminal cases, particularly at least during this period. At the bottom, we've got the Kowloon Magistracy, which opened in 1924 and got off the ground in a big way in the 1930s. And from about 1900, the district officers in the new territories also had magisterial and other judicial powers. I'm not going to go into the new territories. That was a world unto itself, at least during the period I'm covering, and it's too much to deal with in such a short seminar. On top of the formal system, there were various informal systems, some of them within the government. The Registrar General, later the Secretary for Chinese Affairs, was often turned to resolve marital and labor disputes. The district officers did a huge amount of mediation, which prevented cases from getting to the courts. And the police and other enforcement agencies sometimes settled things on the street, sometimes in return for money. And there are also formal Chinese institutions. Early on, the Manmo Temple, the District Watch, which is a kind of auxiliary police force managed by Chinese elites, the Donghua Hospital, which became the center of Chinese political power, and the Boulangok, which was established in 1880 to protect women and girls from kidnapping. It had its own detectives, and in fact, the Boulangok and the Donghua Hospital were occasionally accused of acting like a bench of magistrates. They would send out summonses and sign warrants and so on. And within the Chinese community, there was also informal dispute resolution through the various communities. And going down further, Triad and other secret societies had their own codes of conduct. And the one I'd really like to highlight is deportation, banishment. This was a system by which the governor and council ordered the deportation or banishment of dangerous characters or suspicious persons for a term of years, or in some cases for life. It was a complex and evolving system, and it rested on the principle that most Chinese in the colony were aliens and were allowed to live in Hong Kong on sufferance. Deportation was a powerful tool. All kinds of people were subjected to it. Discharged prisoners, habitual gamblers, triads, smugglers, political agitators, troublesome newspaper editors, people the government didn't like, but found it too difficult to prosecute them in the courts. Now, decisions on deportations were made in secret in the Executive Council, usually on the recommendation of the police or Registrar General, sometimes on the recommendation of a magistrate or judge. The courts were usually not involved at this stage, but they became involved when a deportee returned before his time was up. Then he was liable to punishment by the courts, and rewards were given to informants to turn people in. Magistrates could sentence such persons to imprisonment for up to a year, and in the period 1913 to 1931 to flogging. Persistent offenders were sent up to the Supreme Court for longer prison sentences, and in some years in the 1920s, people who were always described as returned banishees were the largest category of offenders tried by the Supreme Court, accounting for 10 or 20% of prosecutions. Now, what the looming threat of deportation meant for ordinary people can only be imagined, especially for those who decided to make Hong Kong their home, and even for some who were born here. As far as justice was concerned, it infected the system in at least three ways. First, by allowing the executive to circumvent the courts. Secondly, by creating a derivative offence, which was not in itself essentially criminal, but easily proved. And thirdly, by encouraging the courts to distort sentencing through shorter sentences or programs of early release, followed by deportation. Well, we'll now turn to the functions of the magistrates in Hong Kong. First and most obviously, they were there to try persons accused of crimes. And in serious cases, they were required to commit the cases to the Supreme Court for trial. They had a very large role in punishing infringers of municipal laws and regulation, their summary jurisdiction. They acted as coroner after the coroner's role was abolished for a long period in the 1880s, right up to, I think, 1967. They heard extradition applications, which were often very time-consuming and very difficult. And they did adjudicate certain personal disputes, for example, maintenance in the case of separation. And they had miscellaneous functions, including licensing of public houses in a way similar to in England. Let's summarize that. First of all, they were there to punish criminals. Secondly, they were there to enforce government policies on public order, health, and cleanliness and morality. Thirdly, their function was to protect the revenue. And finally, as one newspaper put it in 1875, quite boldly, they were there to enforce race respect towards the British colonial state. Now, this was a system, the whole criminal justice system was based on discrimination, inequality, and segregation. In terms of personnel, the police relied on policing by outsiders. The force, although it had a growing Chinese contingent, it was led by Europeans. It had Europeans at all ranks, and it employed many people from India. Judges and magistrates were practically all British in origin. Jail staff were almost without exception Europeans or Indians, which made communication with the prisoners very difficult, except on the most basic matters. And of course, there was a heavy reliance on interpreters and a general shortage of good interpreters. In terms of law and regulations, this was a colony in which it was once said was led by regulation and not by government. It was a form of regulation that was constantly changing because the government could legislate so easily and so quickly. Some laws were explicitly targeted at Chinese. Others were discriminatory in operation. In other words, they were only enforced against Chinese. And there was an emphasis, certainly at the magistracy level, on control. Punishments were also, in effect, discriminatory. Only Chinese were subjected to corporal punishment, such as caning, whipping, or the stocks. There was segregation in jail between Europeans and so-called Asiatics. And there was an uneven effect of fines. Even as early as 1856, somebody wrote a letter to a newspaper, described himself as a Chinese student of British law. And the thrust of the letter was that fines imposed upon Chinese were equal to 3 months or even a year's wages, whereas the same amounts levied upon drunken or disorderly sailors for the same crimes, actually he was referring to urinating in the streets, would be just a few days' pay. Probably, he concluded, the government do not wish Chinese to reside here. And similar points were made over the decades. We'll get to some of it later on. First of all, though, let's have a look at some of the discriminatory laws, usually referred to as class legislation. Now, some of them were explicit, particularly in the early decades. 1857, there was a series of ordinances for better securing the peace. These introduced requirements for registration of Chinese households and their tenants, and it also introduced the deportation apparatus. Although it was a war measure, it was retained for many, many years afterwards, right up until the deportation system was revised in the 1870s. Then we have something called the Regulation of Chinese Ordinance. Again, it had registration requirements, requirements for permits for processions, theatrical performances, meetings, and the posting of placards. And then this curious thing called the Chinese Marriage Preservation Ordinance, which made adultery by Chinese women and their paramours an imprisonable offence. So it managed to be both sexist and racist at the same time. It came after years of lobbying by leaders of the Chinese community who pointed out that since the Bible prohibited adultery, why shouldn't English law also do the same? Eventually, the government agreed when the New Territories elders complained in the early 1900s that their wives were beginning to leave them now that the district was under more liberal English law. Ordinances that discriminated by operation, the Contagious Diseases Ordinance 1867. I think you've had a talk on this quite recently, so I needn't go into detail, but this was a system of regulated brothels modeled on similar laws in England and other colonies, but it applied in practice only to Chinese women in so-called European brothels. And it required them to test regularly, and if they were shown to be infected, they were then committed to incarceration in a lock hospital. It was highly punitive, oppressive, and a great field for corruption. The system was finally abolished in the 1930s. The Prepared Opium Ordinance, I'm going to look at a bit later, but let's just say a little about the two political ordinances. The Peace Preservation Ordinance, first enacted in 1884 and expanded over the years. This was modeled on Irish precedents, and it was designed to deal rapidly with riots and demonstrations by increasing police powers and indemnities, and through enhanced punishments and enhanced deportation powers. It was last used in 1966 in the Star Ferry riots. And then the Emergency Regulations Ordinance 1922, which was a bit of a talking point last year. This ordinance enabled the Governor and Council to enact legislation without going through the Legislative Council. It was more draconian than similar laws elsewhere in the empire, and from the 1920s, an extensive code of emergency regulations evolved in parallel to the regular law. And at times of crisis, in 1925, for example, and in 1967, the ordinance was used temporarily to confer on magistrates extra sentencing powers for certain offences. And from 1925 to 1941, it was also used to erect a system of pre-censorship of Chinese newspapers. This is a slide showing the caseload of magistrates over the years, again at 10-year intervals. They were always referred to as prisoners, whether they were convicted or not. And as you can see on the far right column, the percentage of population was pretty high, very high in some years. It all depended on enforcement. And of course, it relies on an assumption that these figures are correct. By the way, the equivalent figures in England, including London, would be about 2.5%, although such comparisons, I think, are not always very helpful. Now, jurisdiction and sentencing powers. These evolved in a very complex way, and I'm going to show you a simplified table. There are 2 points I want to make. One is the quite rapid expansion of magistrates' jurisdiction to cover offences that were previously triable only by jury. Now, a similar process was going on in 19th century England and in other jurisdictions, but in England it was much less gradual. It was much more gradual, always with the option of jury trial for indictable offences that were also triable by magistrates. In Hong Kong, it happened quickly. It covered more crimes, and from an early stage, magistrates had greater sentencing powers than their counterparts in England. Here it is in 1844. They were tasked with trying minor offences, with a maximum sentencing power of 6 months imprisonment, along with powers of flogging and other punishments and fines, of course. This was gradually expanded in the 1840s and 1850s to cover larceny, burglary, housebreaking, extortion, assault and battery, counterfeiting, escape from prison, and so on and so on. And then suddenly in 1862, a new ordinance comes out, which empowers magistrates to try any crime, misdemeanor, or offense punishable by fine, imprisonment, or whipping. Now, this covered a huge range of crimes. Of course, they could still send cases up to the Supreme Court, and they still only had maximum sentencing powers of 6 months. And then in 1875, a crisis occurred. The judges, the Chief Justice in particular, Sir John Smale, who's famous for throwing spanners in the works, suddenly declared that the effect of this 1862 provision was actually to decrease the powers of the magistrates over larceny and some other offences, because these offences were not only punishable by fine, imprisonment, or whipping, they were also punishable by penal servitude, which in fact barely existed in practice in Hong Kong, but it was there in the legislation. So this judgment, this declaration raised into doubt all of the sentences for larceny and for several other crimes that the magistrates had imposed since 1862. In fact, this created a panic within the government, and some, as well as some stern words from the judges. Here we have Smale, I think, saying that it was scarcely imaginable that the laws that most closely touch the ordinary people were in such a complicated mess and were in such a state of confusion. Typical Smale statement. But the government took action, and what it did in 1875 was to draft an emergency bill which effectively gave magistrates power to try any offence except offences that were punishable by death or by life penal servitude. Again, they could still send things up to the Supreme Court, but it would have meant that anything other than murder, rape, and some other serious crimes could have been dealt with by the magistrates. Now, the judges would not have this. They would not allow this. And at the last minute, this was supposed to be enacted in a single session, but at the last minute, they came up with a compromise, which was a list of reserved offences for the Supreme Court. I won't go through the whole lot. In fact, it's only the top 3 and probably 1 or 2 others from near the bottom that really mattered. Some of you may notice this is actually not far away from the current reserved list. And in fact, it was based on the list of offences that quarter sessions in England at the time were not allowed to try, offences that had to be tried by the assizes. Well, we go back to our chronology, and another attempt by the government to extend jurisdiction happened in 1890. This was for a brand new magistrates ordinance, drawing in part on provisions in England. And while it went through drafting and while it went through LegCo, and at the final committee stage, the government suddenly suggested, why don't we raise the maximum sentencing powers to 12 months? And it went through practically with no debate. As a result, the number of cases committed to the Supreme Court went down even further. There were very few criminal cases committed for trial anyway. Defendants had no option of trial by jury. And the reliance on deportation as a substitute for long terms of imprisonment meant that depending on the charges, much of the serious crime could also be tried in the magistrate's court. This table, this graph, shows the gradual decline, particularly in the early 1890s. And here's the statistics. It may not be very legible, but these are the statistics for 1894, when the Chief Justice, Sir Fielding Clark, began to get a bit annoyed. He wondered why there were so few cases coming up to the Supreme Court, and he tried to get the governor to change the jurisdiction of magistrates back to 6 months. Governor refused, so the Chief Justice went to the Secretary of State. There was a very big toing and froing of correspondence, which is actually quite helpful because it gives us some idea of why summary justice was so important in Hong Kong. And these were the arguments that officials put forward. First of all, it was a matter of economy. The Supreme Court was very short-staffed. It only had 2 judges at this stage. And criminal trials the criminal sessions only took place every month, so they were concerned about the length of trials and the cost of trials and waiting times. There was a lack of confidence in juries. There were language problems, not because jurors were Chinese, a few of them were, but because of the cosmopolitan nature of European society in Hong Kong. A lot of jurors simply didn't understand what was going on. A lot of jurors were very reluctant to serve. They couldn't be bothered. And there were problems, of course, with evidence and procedure. The technicalities of English law, particularly in the early decades, led to acquittals. There were discrepancies between evidence given at committal before the magistrates and evidence given at trial. And there was a good deal of witness tampering and abscondment of witnesses in between committal and trial. And the officials argued on the basis of Chinese expectations. Summary justice, there was summary justice by magistrates in China, and Chinese were unfamiliar with English law. And they said that the magistrates worked under close supervision by the Attorney General and the government generally. Here is what one of them said, James Stuart Lockhart, the Registrar General, who said the Chinese didn't want jury trial. They would much rather have a case dealt with summarily by a magistrate with common sense and a knowledge of the Chinese language and customs than by a jury, the members of which, who even if they have common sense, are unable as a rule to apply it in the case of Chinese, of whom they are profoundly ignorant and against whom, as a consequence, they are not infrequently prejudiced. Well, the Chief Justice would have none of this. He said, if you ask the Chinese compradors and the Chinese elites, of course, that's the kind of answer you're going to get. And he said that those who were the prosecutors were generally reluctant to go to court, and they thought it was highly ridiculous to have such a careful trial by jury, particularly where the accused belonged to the coolie class. Clark got his way, and in 1895, it was put back to 6 months on the instructions of the Secretary of State. And it remained like that all the way up to 1941. December 1941, and it was actually the 11th of December to be precise. And as is well known, this was when the Japanese were poised to cross the harbour and invade Hong Kong Island. There was practically no business going on in the magistracy at that point anyway. So as an emergency measure, jurisdiction was increased to 24 months. Certain crimes that could only be tried in the Supreme Court could now be tried in the magistracy. Well, we've reached 1941 rather quickly, but let's go back a bit and look at the qualifications of magistrates during the high colonial period. Here they are in the order that was usually given by governors. Knowledge of the Chinese character, ability in the Chinese language, and last and probably least, legal knowledge. There are usually two magistrates usually sitting separately, occasionally together. Sometimes there was only one. There was a gradual increase in the 1930s to 5 magistrates, 1 or 2 of them sitting in Kowloon. And the magistrates were salaried officials, like the stipendiary magistrates in London, and they were appointed by the governor. There was minimal involvement by unofficial JPs. I've already mentioned the petty sessions. Now, with all of those qualifications, the ideal candidate would surely have been a Chinese. And here he is, Choi, the first and only Chinese magistrate in pre-war Hong Kong. It's probably the most famous picture of any magistrate in Hong Kong history. It's reproduced over and over in books and on websites. Was a protege of Sir John Hennessy, a trained lawyer, formerly an interpreter in the magistracy. And his appointment, like a lot of Hennessy's measures, was controversial. There was a question in Parliament, and there were complaints in the Hong Kong press that he was being too lenient towards Chinese defendants. Generally, as far as it's possible to understand, his decisions and sentences didn't really differ much from other magistrates at the time. He served for barely a year. He was the only, as I said, the only Chinese magistrate in the whole of Hong Kong's first 100 years. He left Hong Kong at about the same time as Hennessy and went on to an impressive career in the Chinese government. The other magistrates were all from Great Britain and Ireland, and they were basically made up of 3 categories. The men on the spot, the famous William Kane, Charles Hillier, Charles May we'll look into in a minute. Lawyers, some of whom lasted quite a while. These were qualified, trained barristers. The early ones didn't last very long for various reasons. Thomas Callahan had a breakdown because the workload was just too much for him. And this category called cadets. Now, these are the forebears of what we now call administrative officers, or AOs. They were specially recruited from Britain. They were trained intensively in Chinese, and they rose in most cases to high office, sometimes to the position of governor of a colony. They were favored by governors and as magistrates because of their fluency in Chinese and their loyalty. And from the late 19th century, they were formally given priority in appointments to the magistracy. Some of them, 4 of the names mentioned here, actually obtained legal qualifications while they were on leave, and some went on to become judges in Hong Kong or elsewhere. But most of the cadets didn't have legal qualifications, including some of those who served for quite a long time. This didn't matter to governors who were really just keen on their fluency in Chinese, not so much that they could try cases in Chinese, but in order to keep a close watch on their interpreters. Most newly recruited cadets were given a short posting in the magistracy or registrar general's office to deepen their understanding of Chinese language and customs. Here's one of the men on the spot, Charles May. He was brought over as chief of police, and he was notorious for not being able to communicate with so many of the force because he didn't speak any other languages than English. And he was a magistrate for 17 years and had various other positions. He was a great fan of corporal punishment, although it was beginning to be restricted during his time. Hennessy, the Liberal governor, was very impressed by him and even proposed to make him a judge at some point. That he was persuaded not to do that. Others, including Daniel Caldwell, his former friend and now an enemy, criticized him for really being out of touch and not familiar with Chinese or Chinese people. Here's one of the legal magistrates, the first judicial officer to be born in Hong Kong, educated at Central School, fluent in Cantonese, and he worked his way up through the Supreme Court, studied for the bar, and was magistrate for 16 years, and even acted once as Chief Justice. He was reputed to be a great prober of the Chinese mind and a stickler for demeanor. This one I think I'd like to focus on a bit more. This is Henry Ernest Woodhouse, who was one of the cadet magistrates, no legal qualifications, but he was a magistrate for nearly 18 years. And for some of those years, he was the only magistrate. And for 12 of those years, he was also the head of the fire brigade. He was one of the best Chinese speakers in the government. He was hardworking and by all accounts, a decent fellow and a good colleague. But as we know, for most cadets, the magistracy was just a stepping stone. Woodhouse, on the other hand, was repeatedly disappointed in his applications for promotion. He complained over and over about his inadequate salary, his rising workload, and the burdens and dangers of being a fire chief. In his last few years as a magistrate, he was appointed to the Executive Council, probably as a kind of consolation prize. This was the last time a judicial officer sat on EXCO. Why did he not get on? Well, he had a difficult time with some governors. Hennessy banished him from Government House because Woodhouse had taken one of the younger cadets, Lockhart, to go and see a Chinese brothel. He was also described by Governor DeVoe as singularly lacking in judgment, albeit good at being a fire chief. He was the father of several children, one of whom was P.G. Wodehouse, the famous novelist of the 20th century, who described his father as normal as rice pudding. What sort of things was Woodhouse doing? Here's the statistical return for 1891, which is roughly about halfway through his period. There were 16,382 defendants or prisoners, most of them men. Over 150 offences are listed, and the conviction rate was 85%. Let's try and boil that down a bit. These are the most common, 12 most common magistracy offences from that return. Assault and disorderly behaviour, illustrating some of the violence going on. Larceny, a real crime with real victims. But I think most of these crimes are actually crimes of regulation, and municipal crimes and revenue crimes, as they were usually called. And these top 12 cases account for 82% of all cases. And looking at this larger period, 1881 to 1931, 5-year periods, these are the 5 top offences in those years. And on the far right is the total number of cases in that year. The percentages of what proportion of those cases were made up by these 5 great offences. We can distill that further, and we'll see 5 cases really come out strong. Gambling, hawking, opium offences, and this offence called out at night. Let us go into that a bit more deeply. What does it mean? It's also usually known as the light and pass regulations. And this was in force all the way up to 1897. And we might as well call it what it is. It was a curfew on Chinese inhabitants. You could get exemption in the form of passes issued by the government. But even if you had a pass, you had to carry a light, and the penalties included fines and imprisonment. There was huge fluctuation in cases year by year. In 1891, we have 95 prosecutions. But then in late 1895, the prosecution rate suddenly shoots up to nearly 1,500. And in 1896, we have over 3,000 cases, most of them clustered in the early months of the year. And the fines for these offences ranged from 25 cents to $30. 852 people were imprisoned during that blitz. The reason was high crime, rowdiness among the labouring population, and a number of quite spectacular robberies. It caused outrage. And in December 1895, several hundred members of the Chinese community met at the Donghua Hospital to protest. And they complained that it was class legislation and that it was destroying the hospitality industry. A deputation went to the governor, Sir William Robinson, who was furious at this accusation of class legislation, calling it a false, a monstrous statement. You Chinese, he said, know that there is no place in your own country where you can live so quietly, so free from disturbance or interference as Hong Kong. Or if there is, it only surprises me that you do not go and live there. That was what he said to leaders of the Chinese community. And he continued and said he knew who the agitators were, and if they carried on agitating, he would take steps against them, meaning no doubt deportation. Curfew carried on, but then in 1897, the system was suspended, never to be imposed again. Here's a picture of a night pass from the 1860s, signed for a servant of a European, signed by the head of police. Now, the other big offence was gambling. This was a colony-wide pastime. It went on all over the place. And it was seen by particularly by the elites, as a cause of all kinds of problems, ranging from the breaking up of family to suicides and crime. In 1868, Governor MacDonald introduced a system of licensed gaming houses in order to try, he claimed, to control the problem. These were enormously popular. They were only open to Chinese, and they were also banned to Chinese servants of Europeans. It netted a massive revenue, but the moral outrage was so great that it had to be ended in 1872. Then there was a policy of toleration. And then in 1891, stringent new legislation, heavy fines, 9 months imprisonment for keepers of gaming houses, caning for boys, and deportation for professional gamblers. There were big enforcement campaigns starting in 1891. The governor, Robinson, thought that he'd cured the problem, but of course it carried on, and it became one of the big sources of police corruption. There were two big scandals in the 19th century. And then opium revenue. Well, the opium offences were not dangerous drugs offences, they were revenue offences. The opium revenue was a tax on prepared opium prepared and sold retail for smoking within the colony. And up to 1914, it was managed by a so-called opium farmer. It was auctioned off for various intervals. Then in 1941, it was taken over by the government wholesale. This was part of the program of trying to contain opium smoking because there were serious moral objections to it. The government took over the whole apparatus and even operated the opium boiling factory in Wan Chai. So it was effectively a state enterprise. And the revenue from the opium monopoly was crucial to the government's operations. Even in 1890, it was 24% of total revenue. That's the equivalent of, in proportionate terms, of profits tax today. And it rose and rose, especially after the government took it over. It rose to 8.7 million. And there were official views in response to various questionnaires and commissions from the UK trying to understand the opium trade and working out how best to wind it down. Now, one governor, Sir George William Defoe, this was the year before the outbreak of bubonic plague, he goes so far as to suggest that opium was responsible for the fact that the population was healthy despite the appalling state of sanitary affairs in the colony. This is another view from the Treasurer. It was quite common to compare opium smoking with drinking. And he says the government should be thankful that they have imbeciles rather than maniacs to deal with among the intemperate proportion of the Chinese community. Colonial surgeon chips in. He's tried it many times and it doesn't have any effects. He's also researched into it in the prison. The opium farmer, the man who runs the farm, takes the opportunity to advertise the product, I guess. It's only the magistrate, Woodhouse, who raises some doubts. And he says that it would be better if a different way of obtaining this revenue could be organized. He suggests a tax on trade, which would have been impossible. And he talks about the hardships and irregularities that fall entirely on the Chinese population. Now, prosecutions were necessary to maintain the revenue. And this is a graph showing in red the number of opium offenders brought before the courts, and in blue the thousands of dollars that were raised in opium revenue. I won't try to correlate the two lines. Maybe there's not much to correlate, but just to say that the big surge in the 1920s was the result of raids on opium divans, which brought in, well, as it says here, thousands of people. They decided after a few years of that to abandon the raids because they were entirely ineffective. The opium divans were opening up just as quickly as they were being closed down. The illegal opium divan operators were using proxies to go to prison, who were compensated when they came out, and it was an utter disaster. Many, probably over half of these people went to jail. Because although they would have been fined, they were unable or unwilling to pay their fines. And this came to a bit of a crisis in 1895, the huge numbers of people who were going to jail because they couldn't pay their fines. The outgoing Chief Justice, Sir Edward Ackroyd, or Edward Ackroyd as he only was then, gave a speech at something called the Odd Volumes, which was a kind of literary society, and drew attention to the kind of fines that magistrates were imposing. He gives examples from the report of the previous year. And he says, you're basically sending ordinary, decent people to prison, keep them out of jail as long as you can. For goodness sake, do not send a man to prison simply because he's not a millionaire. This was a speech given in front of the governor and the magistrates. The magistrates were mortified. They wanted a right of reply, but The governor thought best of it and said no, but he gave them his support. And then later on in 1908, we have this other comment among the magistrates' papers from the Schroff, the accountant who collected the fines in the magistracy, asking for a transfer because he couldn't stand seeing people crying when they had to pay, when they couldn't pay the fines, and also because he personally had harsh treatment from the police. Just to give an example, this is the table of conversions based on the English legislation in England, although they had to add an extra line because of the extra jurisdiction. And this, just for comparison, is what people were being paid in 1894, just before that speech was made. Vast gaps in income. But what else could the magistrates do? As they pointed out, and as other magistrates pointed out, they were there to implement the law, and they couldn't do justice according to their own taste. And the problem of imprisonments in lieu continued some years in the late 1920s, even when the opium prosecutions were going down. The number of admissions to jail for so-called non-criminal offences were well over 70%. And this explains why Victoria Jail was so chronically over capacity and why proportionately Hong Kong's prison population was about 5 times that of England and Wales, although England also had its problems with imprisonment in lieu. This wholesale imprisonment of people who couldn't pay fines played havoc with prison policy. Short-term prisoners were reported to be the most troublesome of all inmates, partly because they weren't eligible for remission. Some refused to work and they were punished by caning. Many others couldn't work because they were already too ill when they were admitted. And confinement in separate cells, which was considered the best deterrent in those times, was simply not possible because the jail was so overcrowded. So they all slept in association in dormitories. Various methods were used to try to make things even worse. They were put on basically on starvation rations, though any who were in for less than 2 weeks were basically just given rice and water. Those who were in for under 6 months were given a bit more. But in the eyes of some medical men, it wasn't enough to enable them to work. This policy was abolished in 1921, but it was still a pretty rough diet. They tried to expand the jail. They built a branch prison in Lai Chi Kok in 1920, and they opened that grand prison at Stanley in 1937. But it was soon accommodating prisoners at double capacity, and they had to reopen the old jail to accommodate that. Another method was to use alternatives to jail. One of them was the reintroduction of the stocks in 1903. It had always been available, but it wasn't used very much. Suddenly, one magistrate, Thomas Sercombe-Smith, a future judge, decided to sentence people in large numbers. It caused huge resentment in the Chinese community, partly because of the pitiful state of some of the people who were exposed in the stocks, to a maximum of 6 hours. So it wasn't so cruel. And they were also outraged because it was a punishment that was only imposed on Chinese. When the stocks were abolished, the other non-carceral punishment, flogging, was increasingly resorted to, particularly for boys who made up a large proportion of the defendants before the magistrates. And deportation. Here are some views by legislators and by an observer. CUHK basically arguing that this was the punishment that was still being used in China, and most of the criminals came from China. Hawkeye saying if you impose it on Europeans as well as Chinese, people might be a bit less unhappy. And then this American visitor, John Thompson, who talks about stocks being used as a kind of way of imposing awe on the population. Now, things did improve. The late 1920s and 1930s, there was an expansion, a very modest expansion of the judiciary, additional judges and magistrates, up to 5 magistrates by the late 1930s. There were more progressive views among the governing elite, and there was a development of civil society and a certain civic consciousness. And new offences came into the magistracy, especially traffic offences, dog offences, because of the problem of rabies, not having a license or not muzzling your dog, very, very big offence. Muay Thai offences and dangerous drugs offences. And there were reforms. A juvenile court opened in 1933. And in the late 1930s, there was a professionalization of the magistracy. Magistrates came under the supervision of the Chief Justice rather than the Colonial Secretary, and the cadet magistrates were phased out and replaced by lawyers. Here's one of the last cadet magistrates, Walter Schofield. He's famous a bit in Hong Kong because he was one of the pioneers of archaeology, but he was also a very humane and decent magistrate. Rather like Woodhouse, this was the end point in his career. And he was very reluctant to fine people heavily and somewhat shocked by some of the cases that came before him. Here are the new lawyer magistrates. Part of this was in order to accommodate the new colonial legal service, but some of the magistrates, the lawyer magistrates, were recruited from within Hong Kong. The oldest one being Harold Sheldon, a well-known Hong Kong barrister. And in Kowloon Magistracy, we have in Donald Anderson, a very young, recently admitted Hong Kong barrister who's basically of Hong Kong origin, of Eurasian descent. His uncles were both, his great uncles were both, his grandfather and his great uncle were interpreters in the Magistrates' Court and the Supreme Court. He was killed not long after his appointment during the Battle of Hong Kong. In the 1930s, a lot of the reforms were vitiated by the huge increases in population. Many of them refugees from the advancing Japanese invasion. And the work of the magistracy almost became uncontrollable. The number of defendants increased quite rapidly in the 1930s. And the biggest problem was the hawker problem. Hawkers now accounted for up to half of defendants in some years in the 1930s. They'd always been a big category. These were hawkers without licenses or hawking in the wrong place. And they made up about half the prison population. A large proportion were children. Not many of those were not by now being sent to prison. They were being caned or just given a warning instead. And there were criticisms by legislators about the extent of police enforcement. The magistrates responded with token fines, payments out of the poor box to help people journey home if they could, or to get licenses. And in there were also proposals for alternative policies, such as internment camps instead of prison. And in 1939, after a series of extortion cases, the magistrates on Hong Kong Island started to discourage hawker prosecutions, and less arrests have been made under the supervision of a European sergeant. And this led to a huge drop in hawker cases on Hong Kong Island that year. Well, I'm going to conclude with a few observations. I want to stress, though, that this is work in progress and it's possible to view the magistracy from many different angles. So I only put these observations through tentatively and not as conclusions. Well, first of all, the Hong Kong Magistracy was an example of how summary justice developed in British-derived legal systems in the 19th and 20th centuries. Secondly, it was a court of justice. I want to stress this because I've spent a lot of time talking about these regulatory cases, but it was a place where people could obtain justice, where real crimes were tried, and justice was very often done. But it was also a key part of the machinery for controlling and disciplining the Chinese laboring population. And this process was exacerbated in Hong Kong and justified by a number of problems. First of all, the geographical position on the edge of China, which had all kinds of implications. Secondly, related to that by the fact that the population was, for much of this time, very fluid, constantly expanded and not very settled. The colony had very limited resources and was very loath to spend money on justice and on prisons, although it was very happy to spend a lot of money on the police. There were very high crime rates, and there were huge inequalities in wealth, and the elite attitudes were influenced by racial and class prejudice. Now, these inequalities especially influence legislation and punishments and the way that justice was administered. But ultimately, a lot of it was pretty nugatory because this reliance on fines of imprisonment to regulate things like gambling and street behavior and the revenue ultimately was a failure. I haven't gone into individual cases, but here are some recommendations for further reading and research. Of course, I recommend the book, and I understand there is a discount available for that, a generous discount. But if you want to just go online, there are some excellent resources. One of these is Hong Kong U Digital Initiatives, which has a wealth of information, of statistics, opinions, cases, and so on. And another one for more detailed descriptions of individual cases is the Public Library's website, the MMIS, search under old newspapers. You have to, at least for the English language papers, you have to penetrate through a veil of racism and sarcasm to get to the real essence of a case. But I think they're worth having a look at. I think, would you like me to pause here, or should I just?
Well, you've actually gone just on the 75 minutes that you're talking about. You can carry on a few minutes more if you want to on those other bits.
Okay, I'll just give the slides, I think. Developments after World War II. Well, big changes. I'm not going very far beyond World War II. There was a new outlook in colonial government. It didn't last very long because of mass immigration and the revolution and civil war in China. And this drove mass immigration into Hong Kong, along with gangsterism and a lot of crime, and it produced extreme social problems. But opium was classified now as a dangerous drug immediately in 1945, and possession of any form of opium was illegal. This sudden change, which caused quite a lot of problems for some people. Some forms of gambling have been legalized progressively since the war, thanks to the Jockey Club. And road traffic offences came in a big way, along with some other modern offences. the problem after the war with the surge in population was this massive congestion of the courts. It was phenomenal all the way up to the early 80s when there were over 1 million people. The solutions were obvious in some ways, and they were pursued. Next slide. The magistrate's jurisdiction was retained at 2 years imprisonment. The district court was established in 1973 to take pressure mainly from the Supreme Court, which was also under considerable pressure at this time. And new magistracies were built throughout the colony. Some of these buildings still exist. And there was a large increase in magistrates, going up from 5 in 1950 and up to 36 in 1970. And from time to time, the use of unofficial JPs sitting in 2s or 3s for things like traffic offences in the 1950s and littering offences in the 1970s. And there were procedural reforms. I won't go into these because a lot of them I think are now familiar, but they came in gradually and they were expanded gradually. And there were new forms of punishment. Following, with modifications, the new punishments in England. So that fewer people, particularly young people, were going to jail, but they were going to these new institutions, training centres, and detention centres instead. They now, I believe, have different names. But some old punishments persisted. In 1947, there was extensive caning of boy hawkers, mainly to stop them going to prison, but there were so many cases that there were questions in Parliament about this. And in 1970s, during the great fight violent crime campaigns, caning was revived with the encouragement of the then Chief Justice, Sir Ivo Rigby, who really wanted to keep people out of jail and had some rather interesting views on punishment generally. Many of the magistrates in the post-war years, until very recently, were imported from the UK and from other Commonwealth places. There were some very good ones. In fact, most of them, they were all qualified. Most of them were as good as you could probably get. One I'd like to single out, because there weren't that many Chinese magistrates before the 1980s, but this one I'd like to single out, Law Hinsing, who is very much a Hong Kong person. He lived to be 100. He was born in Hong Kong, educated in Hong Kong, called to the bar in London after a very, very long education, and practiced in Hong Kong before the war, mainly in criminal practice. After the war, he'd advised the Japanese during the war on English and Chinese law. After the war, he was appointed a magistrate, and he served as magistrate with a few breaks all the way up to 1970, when I think he must have been about 80 years old. And he said shortly after his retirement that in an interview that crime can only be reduced through free universal education and better control over children by parents and teachers. And he said, we need a more equitable distribution of wealth to narrow the gap between the small portion of too wealthy citizens and the bigger portion living from hand to mouth. I think that's a statement that many of us can agree with, and I think I will conclude. And thank you all for your attention. Thank you, Steve.
Thank you very much. That was excellent. Thanks, Chris. And thanks for covering such a wide subject, dead on time as well.
Thank
you. Leaving a little bit of time for questions. So I should have said that at the very beginning. Please, if you've got questions, you can use the chat function to come in. I thought that was very interesting, your comments as well about the opium earlier on, with doctors actually saying there's no problem in having opium. It's good for you. I can understand why P.G. Wodehouse probably used some of his father's experiences with his legal characters and his medical characters as well in there. It was also interesting because, of course, you were talking about Tai Kwun. I know when you go and visit Tai Kwun now, that point you made about the diet of the prisoners, I know they've got on display there they show the rations, and of course, going to visit, especially for people who've never visited a prison and seen the conditions that people have to live in prison, it's quite shocking to see how small the cells are, and realise that more than the number of prisoners that usually would have been there were then squeezed in, and then see what sort of diet they were to have. But I thought that was your comment about the stocks. So only the Chinese were put in the stocks?
Yes, very definitely, yeah.
But for the corporate punishment, that could have been for anyone, couldn't it?
It was by ordinance, by law, but it was only in the 1950s when magistrates started imposing flogging on Westerners. That was very controversial. The tabloids in England were absolutely shocked. So a lot of them were actually servicemen, soldiers and sailors. But before 1941, I can find cases of people from other communities, such as the Portuguese community and the Eurasian community, but I've not yet come across a case where flogging was imposed on a European. One judge in the 1860s, one Supreme Court judge, tried to impose it on a couple of down and out Europeans, but the outrage was so extreme, and there was petitioning by the colonists that one of them definitely wasn't carried out, and there is no record that the other one was carried out. So it was definitely just Chinese.
And was this in line, do you think, with the idea that these were Chinese punishments? This was
yes, indeed. Yeah, the rationale. But do remember that flogging was, or caning and flogging with a cat was still an English punishment up to 1948, although I think it was used much less often than in Hong Kong. But the rationale was always, this is what is done in China, and therefore, in order for punishment to be deterrent, that is what we have to do here, subject to considerations of humanity and proportion and so on.
Well, you mentioned that going back to the 19th century, John Pope Hennessy. I mean, my understanding was he was quite liberal and he didn't like this idea of those punishments.
Yes. He was most shocked. In fact, by then the magistrates were probably only accounted for 1% of magistrates' punishments, even before he arrived. And his main concern was, two main concerns. One was the huge amount of flogging going on in the jail under the authority of the jail superintendent, who had greater powers than his counterparts in England. He didn't have to consult a magistrate or a director of prisons. So that was a concern. And the amount of flogging in jail was just out of all proportion. It was on a sadistic scale. The other concern that he had was the public floggings, which were mainly ordered by the Supreme Court. And these were public whippings with the cat of nine tails on a flogging post outside the harbour master's office, one of the busiest places in the colony. And the prisoners would be marched down from the Tai Kwun, from the jail, all the way down to Weston, and they would be flogged in front of an audience. And indeed, in some cases, grandstands were erected for the colonial officials and invited guests, I guess.
So, but that idea of the earlier hangings,
yes,
hangings.
I think it was it's sort of, whereas in England things were being reformed gradually, in Hong Kong there was this hangover from the Georgian period, from the bloody code, and because of the need to show a deterrent, things like hanging people in private didn't really catch on in Hong Kong until several decades after the reform was made in England. A couple of decades after, anyway, 3 decades after.
But that was interesting because, of course, then you said that Hennessy was quite friendly with May, and May
yes,
seemed to be very
yes, indeed. I think May was probably the grand old man in government by then, and yes, May's comment I remember was from 1862, which was when the government was under pressure from London to cut down the flogging, and again there was this campaign, like with the opium questionnaires and like with the jurisdiction issue. There's a campaign is mobilized to stress to the home government how things cannot be reformed over here because they're so different.
Yes, they seem unlikely friends in many ways.
Yes, I think so. May died during the middle of Hennessy's governorship. He went home on a long overdue leave and he died on the voyage home. So there was a certain amount of politeness, I think. But it's very odd that Hennessy put his name forward as an acting judge. This man may have no legal qualifications, and if that 1875 legislation had gone through, and the magistrates could have tried almost any offence, then it would have been May who would have been the first magistrate to do that. I don't think he was a bad man, but I think he was a good example of the kind of people who were around at the time.
Yeah, it's difficult to judge people by today's standards.
Definitely, yeah.
As well. Do you think there was also a link, because of this emphasis on corporal punishment, I'm sorry to go on about this, but to do with the military as well? Because I think it was still being used.
Yes, it was still being used. I think it was abolished sometime in the late 19th century in England. The only actual connection I can find is that when they had this big commission on flogging in Hong Kong in 1895, one of the witnesses talked about this beautiful cat of nine tails, which had been woven by some naval man and had been donated to the jail, and it was a beautiful object. But I'm not sure about the connection. There's certainly there probably wasn't much of a conscious connection, I would say.
Actually, I've got questions. I know we've nearly run out of time, I'm afraid. But
yeah, sorry.
That's me, no, it's me. It's me asking about these things. I was so interested in this. But we have got a question about the architecture and layout of the Central Magistracy and the jail. If we look at it from now, it looks like a one-stop service. But going back to the early colonial times and in the context of summary justice, is there any evidence suggesting it was designed to be in that way, a sort of one-stop shop for everything?
I think it just happened like that. This was always the site for the jail and the magistracy. Even before the 1847 building, there was a magistrate's house where I think people were tried. I don't like this word one-stop shop because it suggests that people actually went there willingly. It wasn't a one-stop shop in that sense. And I think there were common, these arrangements were common in many other colonies as well. And indeed, the magistracies in London, they were originally connected with police stations. One of the reasons why they were called police courts, but not the only reason.
Right, thank you. I mean, I've spoken to lawyers in Hong Kong who've told me that they actually went there, to represent their clients, and then visiting the clients in the cells in the police station, going to them, and then later on seeing them in the jail. Or whatever.
In that sense, it's a one-stop shop. Yeah, for sure, for lawyers, definitely.
Apologies to those people who sent in questions because I know I've monopolised Chris's time, but thank you very much for such an interesting talk. It's a great subject, and we have got some details about the book coming up as well, and about the discount that's available to purchase the book for those interested. So thank you again. I've got to publicise some upcoming sessions, which I think Vivian and Erin are going to share with us now. So here is there's an ad here for the book, and a discount is available if you order using this particular discount code. So again, I think we can share that discount code with everyone as well, but the discount code is here for you for Chris's book, and of course that's with May Holdsworth as well, and obviously covering this huge topic. And then upcoming talks on the 19th of November, we have the next in the Greater China Legal History Seminar Series, which is Dr. K. Chai Tam from the Baptist University, talking about the controversies on the morality and effectiveness of judicial torture in late Ming China. So that'll be a great topic as well. Follows on from the corporal punishment, I think, in that way. And then on the 4th of November, the Ladies in Our Cross-Border Legal Issues Dialogue, English as Contract Language, Legal Aspects of a Dying Animal. So I think that's the other one to emphasize to you is, of course, our 18th of November, the next in our Female Legal Leaders Seminar as well. So I'd encourage everyone to come along and listen to our speakers in that particular series. So thank you once again to Dr. Christopher Munn for such a great seminar. Thank you to everyone for tuning in today and listening to this great seminar. Thank you to my colleagues for supporting us, for Erin and Vivian and Mark, who are here with us now in the moot court at CUHK Law. And just to remind you all of those upcoming events, please join us for our future events, and to say thank you. And we are CUHK Law. Bye-bye.